Hello, hello. Welcome, everyone. Welcome to the Founder in Climate series. And we're really excited to have our third session today. It has been hugely successful. And as housekeeping, I highly encourage you guys to turn on your videos so that we can see your beautiful faces and other people can see you all as well and improve engagement. I am Nagashri. I'm a board member at Women in Cleantech and chairwoman of the Entrepreneurship Committee. If you guys haven't attended the previous sessions, I would like to take a moment to tell you about Women in Cleantech. We are a nonprofit that is helping women in clean tech and green tech solutions to help bring about parity as well as network with other women and bring their thought leadership and local leadership to the forefront. With that, Arila, if you want to go back one slide, I want to talk a little bit about about the Entrepreneurship Committee. So the Entrepreneurship Committee is a part of the WCS program with various other programs like the mentorship program, as well as we have different chapters across United States. We also have a European chapter. And so the Entrepreneurship Committee's goal is to cultivate and support women founders like yourself so that you can find success in what you do, as well as meet other founders through networking and connection and bring your story to the forefront. So the Founder series is first of its kind, and I'm trying to experiment with it. Where it arose from is from the pitch competition. We had a great turnout of women earlier during Climate Week. And when they presented, I did talk with the VCs who were judging them and the women to find what we can do to support the women. The VCs said that we need to elevate these women to the top 50% of investment bracket. And the women founders said that they would like a network, a community to come and meet each other and share stories. So lo and behold, we have brought to you the Founder series. Arila, to the next slide. The way the program is structured is a two-part. We bring a hands-on workshop, like today's session is on Legal 101, where Aravinda today will talk about the legal aspects of starting this journey and starting your own endeavor, as well as we'll have a Friday session where you can come and bring your questions. Today's session will cover the workshop in the first 45 minutes, and then we will leave about 10 minutes for you to ask questions. Please note, today's forum main focus is the workshop. To cover that, you will get an opportunity to come tomorrow, share your story, and ask your questions. I know a lot of people have given feedback. We'd like to talk about us. Tomorrow's forum and the happy hour is exactly for that. Come and share. So like I mentioned, today's session is on Legal 101, and Aravinda, who is on the call today, is going to talk more about it. In terms of our speakers for the Founder series, we have all of these amazing women. What is common between all of these women are they've all had a long-standing corporate career. They've left that to start their own entrepreneurship journey, and they are willing to support women like us who are on our entrepreneurship journey. With that, I'd like to introduce myself. I'm Nagashri Manwatkar, and I am a board member at Women in Cleantech, as well as chair of the Entrepreneurship Committee. I am also a founder of a nonprofit, Gaia Force, that is helping upscale young professionals to land climate jobs. I have a long-standing career in clean tech and sustainability, spanning sustainable buildings, residential storage, and solar at Tesla. And I helped scale B2B Powerwall and solar business there at Tesla, and have earlier stints at larger architectural firms building large infrastructure projects. So with that, I will hand over to Aravinda, and I'll let her introduce herself. Over to you, Aravinda.
Thank you so much, Nagashri, and thanks so much for putting this together. I mean, just there's so much of a desire and a demand for support and community in the women founder circles. I hear some really rough stories about what it's like out there, not only in terms of the percentage of founders that get funding, but just like the whole experience of it, the misogyny, the harassment. It sucks. Okay. It's rough out there. So I want to be honest about that. And yet at the same time, you women who are continuing to, like, nevertheless, she persisted and like continuing to, fight the good fight and create what you're creating. There is community, there is support. There are people that are here to help you, like the WCS organization. And actually, so my story is kind of, I'll tell you guys a little bit about my story. So I'm an attorney. I went to Stanford for law school. I went to one of those big law firms where they had some notable startups. And I pretty quickly realized that they do a pretty good job for other huge multinational corporations. When it comes to startups and investors, they kind of suck. They don't prioritize them. They're very expensive. They take forever to get back to you. And like the associates there may really want to help, but that structure is not lend itself to small startups. So I went to a boutique that was started by someone I worked with. And it was really great. It was very focused on early stage, not out trying to chase these huge deals. But I'd always cared a lot about DEI. So I was president of all these alphabet groups in undergrad and law school. And as a partner there, I was there for 8 years. I was a partner for the last 5 years. I really recruited, mentored, and retained. And when I left, it was actually the most diverse corporate practice I had encountered. So I felt really great about that. But then I wanted to give back to the community. And I did these free workshops and trainings for our own diverse clients. And that's when I realized, first of all, if you build it, they will come is lies that only works in the movies. And secondly, we didn't have enough diverse clients for me to even fill out these workshops. It was shocking to me. And I just hadn't been looking at that as a metric. So I started this law firm, Venturous Counsel, to specifically work with underrepresented founders, investors, and mission-driven companies. So this is kind of a merging of all of those things with WCS in terms of the clients that I support. It is a mission-driven firm. So the goal is that every founder and investor I know has a section of their brain that's just low-key freaking out about legal at all times, right? Like a broken smoke detector that's just screaming in your ear, and it's so loud and it's so annoying. And you took the batteries out. You asked ChatGPT. It didn't turn this off somehow. It's maybe made it louder. So if you are able to find someone that you trust to give the screaming mess to, then not only are you covered on legal, but I would argue almost equally important, you unlock so much mental capacity that you may not even realize was secretly worried about whether you even worried about the right thing. So that's what we're here to do, is be the structural support for our clients that allows them to unlock more capacity, in the things that they're particularly skilled at. And so today I've been practicing for more than 18 years, y'all. This is real. This is the gray hairs are from experience. And so I really want to kind of distill some of my learnings and give those to you to help you think things through and not have to learn through experience for everything, and have some guidelines about how to think about the legal approach. Next, Arula. I have an amazing team. As you can see, it is 9 women and 1 man who calls himself the diversity hire. I like it a little too much when he does that. I mean, I'll be real. They're all people who have been brought together because they really care about the mission. So this is the same firm team that I've had for 3 years, which is like insane for a law firm. There's always people always fire when things are tough. People leave when things are good and they go to other jobs. But everybody in this firm really cares about the mission, really cares about the clients. And so we're able to provide legal service in a little different way, where I've told my clients this is a dumb use of legal spend. It's low risk. Please don't like waste money and do these sorts of things. It's like stuff I couldn't say when I was at other law firms. So yeah, we invest, we represent both clients and investors. Marilyn, next. So I often get these two main questions. So I'm going to knock through these. And also keep in mind, if you have questions and you're worried you're going to forget them, you can put them in the chat. And if we don't get them by the end of the Q&A, we'll talk about them in the office hours tomorrow. So what entity to create? So this depends on what you expect to do with the entity. And what I'll say is that for most companies, there are two main choices. One is an LLC, and one is a C corporation. And I'll explain why. An LLC is really cheap and easy to create and maintain. It's the cheapest, easiest approach. There are also there's some complexity around. The benefits are that if the company makes money, you're only taxed once. So with a corporation, when the corporation sends money to its stockholders, that's taxed. And then the stockholders are also taxed on their gains. There's a bunch of other legalese around it. But if you're not planning to raise angel or VC investment, if you don't need to hire and retain tech folk who expect equity in the company, like options, then an LLC makes a lot of sense. It's the cheapest, easiest, low lift approach. If, however, as may be the case with a lot of startups in this sphere, you do need funding, especially angel or VC funding, to get your company off the ground and to get started and to accelerate, then you don't save money by starting as an LLC in most cases. The tax benefits are like, okay, you're not making profit. What are you even being taxed on, right? Like most startups are not making profit for a little while. There is some ability to take the losses in that business and attribute them to the founder, but like there are different ways around it. But if you plan to raise from angels or VCs, you want to create a corporation, and almost always it's still Delaware. I know there's like buzz here and there about some of these tax-free jurisdictions, but most VCs, it's going to take a while if it's going to change. It's not going to be like one blog post from A16 that's going to change that. So it's still Delaware. Delaware has a very deep structure and case law that helps companies and especially investors and acquirers have a sense of predictability about what would happen in certain scenarios. And other states just don't have that same clear roadmap and predictability when it comes to the courts. Plus, it's just very corporate friendly generally. So Delaware is what I would recommend. You create the entity in Delaware. You have to qualify to do business wherever you are. We can talk a little bit more about that. There is a tool that I recommend for people who plan to create an entity and haven't done it yet, where you literally, I don't have to fix anything. I'm putting it in the chat. It's called Clerky. I get no money. I just am so sick of seeing like a misbegotten legal Zoom formation that I have to charge the client like so much money to fix that if I never see one again, it will be too soon. So this tool will help you to form the entity the right way. They have a lot of belt and suspenders, appropriate vesting language. We'll talk about a little bit more about that later. The question about when to involve a lawyer. It kind of depends on how much you want to save money now versus in the future. The way to think about this, we'll talk a little bit more about this later. But if you guys have heard of the concept of technical debt, right? Where you do something quick and dirty now, you're going to have to kind of redo it. You're going to have to invest more in it later. You can think about legal debt in a similar way. Like you can get by without a lawyer for a lot of things. It's going to cost more later. But if you have no money now and you need all of the money to deal with, your engineer or pay your engineer or whatever, then that's where you are. Just know that if you invest a little bit of money earlier, you save money later. But sometimes you don't have those funds. And then in that case, you're just doing the best you can. And then you know that there's going to be a cost you're going to have to pay in the future. The other thing I want to flag is there's the cost, and then there's the cost, right? There's the cost, and then there's the cost, which is there's a lot of mental load that founders are carrying when they don't have appropriate backup. So just that is something to factor in. It's not something you can always solve right away, but you may want to think about bringing resources in earlier, even if it might be more expensive, because it frees you up so that you can do other things that you're particularly skilled at. You don't have to become a securities lawyer expert. Really, I even barely want to do that. Okay. I'm seeing some questions. I'm actually going to answer this one. There are other forms of structure like sole proprietorships. Sole proprietorships do not protect you from liability incurred by the business. I do not recommend them because if something goes wrong, you're putting something out into the world. You know, maybe you're putting out a tool and someone slips on it and they like cut off their hand or something. You could be liable. They could take away your personal assets. But if you have an LLC, it's very hard for somebody to take away your personal assets. So that's the big difference. Both LLCs and corporations have a limited liability structure. That means that the individuals who form it are not going to be personally liable for any of the issues with the company, generally speaking, like at a very macro level. Oh, and for the LLC, if you're not going to raise, you can have the LLC wherever you're based. I know. Nagashiro was like, don't answer all the questions in the meeting. We're going to have a Q&A later, but I can't help it. Okay, can we go to the next slide? Corporate structure. Generally, simpler is better. Okay. I always have people come to me and they're like, you know, I want that 10x voting stock, that tasty 10x voting stock that Facebook founder had, or I want some sort of weird structure that like locks in my ownership potential. The reality is, whenever you go out to fundraise, so I will say a lot of this conversation is going to be geared towards companies that plan to fundraise, because that's what I'm expert in. Like if you wanted to create an LLC, you could probably do that on your own, have very little legal involvement. And if you did need a lawyer, they wouldn't need our level of expertise. So a lot of this conversation is going to be geared towards companies that plan to raise angel or VC funding. And we can talk about a little bit about that. But my general advice is that when a VC comes to you or an angel and is looking at your company and evaluating on whether they want to invest or not, they have like this much attention span. It's so tiny, okay? And if you have some weird corporate structure where they spend all of their attention span trying to figure out what you even did, there's no space for you to wow them about your product and the impact and the potential upside. So, and the other thing is, because everything is up to negotiation at each financing event. So wait, let me back up. Everything is up to negotiation at each financing event, right? The board structure, the valuation of the company, your personal vesting, all of this stuff is up to negotiation. So you can't pre-negotiate like 10x voting stock or ownership of board. What you got to do is like kill it on the product side, do a really good job of fundraising and reaching out to multiple people. So you have multiple people at the table that are like fighting over you, but who can invest in your company. I love those scenarios. I optimize the hell out of those scenarios for my clients, but I can only do it if there's enough market pressure that allows us leverage to be able to do these things. I've taken a board seat away from an investor and given it to the founders. That's so rare. That's because they were killing it on the product and they had the leverage. So what I'll tell clients is start out totally normal. What you kind of want the investor to do is they look at the corporate structure and they fall into a light coma. Like it's so boring that you can't, it's nothing interesting. And then when you talk about the product, they break out of the coma in a dramatic fashion. This is the goal. Just plain vanilla standard. And that's why I recommend a platform like Clerky that does that for you. It kind of gives you the preset options that are pretty standard and normal. Okay, let's talk about founder matters. Okay. So I will say, most people say, oh, but you know, the main issue for a company is that it never finds product market fit. You would think so. The biggest threat to the company is that there is a founder dispute that is unresolvable. that I see so many cool ideas die because of this. And, you know, people assume, hey, we've been friends for 10 years. We'll get through it. But when you're friends with people, you're not working side by side and having expectations and needing to have clear communications about various responsibilities and who's doing well and who's not. And there's no boss above you making that determination. It's you guys. So the most important decision for a company is who the founders are. And I'm going to say it. Please don't come to me with 7 founders. I guarantee you there's no company that's going to succeed that has all those 7 founders. So that's like you're baking in a founder departure from day one. And I do think women are in a particular position where they're getting a lot of pressure to have a dude because of those numbers, okay, to have a dude on the C-level. And I would say only if the dude's awesome, right? Only if they're amazing communicator, they're really contributing something and they're amazing. It would be better to be a solo founder and like figure it out in terms of the longevity and like the likelihood of success of the company, separate from your ability to raise. Like eventually you'll find an investor that gets it if you're, you know, if the product has traction, if you're getting clients, that's going to show in the numbers. But you can't magic your way out of bad communication and bad founder alignment. For founders, every investor expects that the shares are subject to vesting. Vesting is basically what happens. You can think of it kind of like a reverse option. You get all the shares at once and you're allowed to vote those shares. So let's say we have a 10 million share company. I don't know why. It's 10 million, guys. Okay, that's the standard. So, and it makes the math easy. So you reserve maybe like 1 million for issuance to advisors, consultants, employees. And then the remaining 90% of the company is split between the founders. And it does not have to be 50-50, y'all. Like that is not a requirement. And sometimes that makes things tougher. It is worth it to really talk with your founder, identify who's doing what. How replaceable would someone be? I know that's like, it's kind of like a prenup. You're like talking about what would happen if somebody had to split or if somebody wasn't working out. And if somebody has specific content expertise, they may get more of the company because you can't find somebody else to fill that role, right? And the time that you've been working on something is more related to vesting, whereas the uniqueness of your role and the difficulty of replacing you is more related to your equity ownership. But at the same time, I don't love scenarios where like one founder has like 80% and the other person has 20%. Because like, is that really a founder? They have to feel like it's fair. If they feel like it's fair and it will be fair, then it's fine. But, you know, you'll get questions probably from the investor if that's the case, unless there's a clear reason. Okay, so vesting is this reverse option. So you get all the shares at once. But if I'm an investor and I put like $1 million into the company, what if you just like leave the next day and you take half the company with you? And like, I'm like, well, but who's running this company? Nobody. Okay, well, cool. That is not an acceptable outcome for the investor. They want to make sure that the founders are in it for the long term. So what that means is that if you leave within certain time periods, some of your shares get to be repurchased by the company at cost, which is basically nothing. So if you had a standard 4-year schedule, and there's this cliff, which is called, which is like you don't vest in any shares usually for the first year. And then at that 1-year anniversary, you vest in a quarter of the shares. So it's like 1 year of shares all vest at once. And this allows, you know, especially for employees, this allows you to kind of get a sense of if they're going to work out, give them a chance. And if they leave, they may not get any shares. And now we'll talk a little bit about departures and how to handle those. But this is the standard approach for your vesting 1-year cliff. For founders, and generally not for employees, they also get acceleration, which is generally if the company is acquired and you're terminated without cause, or you leave for good reason, then all of your shares get accelerated. And what that does is protect the founders in a future acquisition scenario where the acquirer is tempting them with this employment offer that's actually BS because they're just immediately going to fire them. So it's making sure that the acquirer is like acting above board and fairly and protecting the founders. Generally, you don't see any change of control acceleration. That's like acceleration based on the acquisition. I can go into the details, but basically investors feel like it's kind of just putting more of the consideration in the founders' pockets at the expense of the investors. Anyway, it's just not something I recommend or that investors will go for. You can have some amount of acceleration based on involuntary termination, which is like if you get fired without cause. That's basically pre-negotiated severance. And I recommend that founders talk about what that would look like. And, if somebody's just not working out, but they've been there for a while, maybe that involuntary termination acceleration only comes into play after they've been there for a year. There are ways to slice and dice it, but the most important thing is clear communication. And that's what I'll say throughout everything. Founders are amazing at executing, sometimes not so great at communicating. And that lack of communication can cause a lot of problems down the road. And if you get that from day one, you're ahead of the game. The other thing I'm going to say, particularly to this community, yes, women and women of color, I'm talking to you, do not issue shares out of charity. Don't issue shares because somebody did you a solid. You feel like you lost, they invested in your last company and they lost money. Everybody investing under security laws has to be somewhat competent and have the ability to lose the money that they invest. Okay. You don't owe anything to somebody who lost money on you. If anything, they probably learned a lot and you learned a lot and now they understand the challenges or whatever. But everybody has big girl pants, and they're adults in the scenario. And the situations where I've seen stockholders create a lot of friction and cause a lot of issues with the company, disproportionately higher when they did not pay for their shares or they did not provide services to get into the company. Furthermore, you want to reserve as much of the company as you can for people who are actually running the company and who will be incentivized by their equity ownership to kill it so that the company value goes up and that their share value goes up. You want to align the incentives in this way. And then all of this said, please don't freak out because over time dilution solves things. The people that continue to be involved have a chance of getting more shares in the company. People that have left don't. So don't lose it. Next slide, please. Okay. I talked about this a little earlier, so I'm not going to belabor it, but one of the differences between founders that are successful and not that I've seen is that the successful founders spend a decent amount of time identifying and cultivating their resources. And this means different things in different contexts, but for legal, it does mean making sure you have somebody in your corner that you can reach out to, that you feel like you can trust. I also think it's important on the tax and accounting side to have some resource in that way. And then also to have a community. So WCS is doing great work in helping you guys already build that community, but you may need a community that's specific to the vertical that you're in. You may need some community that is specific to the stage you're in. Just really be open to that. And we're all social beings and social creatures. And that sense of community can make the difference between making it through a rough patch and not. So really use your resources and don't underestimate how valuable that can be as a general, again, to help the mental load. Now we understand when we have a word for that mental load, right? That women are bearing a lot of in all sorts of situations. And how can you lighten the mental load for yourself is basically the question here. Okay, next slide. We talked about this a little bit as well. Legal debt, think about what you can do near term to avoid issues later term. And the two big tools I'm going to say are the formation tool, if like Clerky, and then also, guys, if you're working with someone, have them sign something, okay? It doesn't have to be the most beautiful negotiated agreement. Find a form agreement. The law firms all make their basic agreements, or most of them make them available online. Even I think you could get Clerky forms if you needed to. I know Oric does. I know Cooley does. I think Goodwin does and Fenwick does. Whatever. Find a law firm that you like their name. I don't even care. Pull down a standard consulting agreement or an advisory agreement and get the people to sign the agreements. Once you have that in place, you can negotiate. But if you are working with somebody and they are contributing intellectual property to your company and they have not signed anything, i.e. assigned the IP to you, you're screwed. If they leave and you don't end up deciding to work together and you can't use their IP, like you don't have the rights to it. And it will come out in diligence and it will make the company uninvestable unless you go in and remove everything that they contributed to. And then even then it's like, well, do we feel like we actually got everything? So if they've signed something standard, it will assign IP to them. And be careful. An NDA has nothing to do with IP assignment. An NDA just is a non-disclosure agreement that relates to confidentiality. I had a client who's like, don't worry, Aravinda. These 80 service providers that have been in and out, I got them all to sign an NDA. And I was like, oh, honey, that's sweet and that's great. But that doesn't solve the underlying problem of IP assignment at all. So we still had to go through and like get her to get everybody to sign as much as they could and then extract whatever we couldn't get signed. And it sucked. Don't do it. The base level is like, make sure anybody contributing to your company is signing some form of agreement, generally an advisor or consulting agreement at the early stages. Okay. Next slide. Okay, so we talked about this a little earlier, okay? And this is also in the theme of communication. Most founders, well, look, nobody loves having difficult conversations. Very few people, maybe just sociopaths. Everybody hates difficult conversations. And yet they're so important for the proper functioning of an organization and even a relationship. And so the number one advice I have on this point is over communicate. If somebody is not doing well, a client will come to me and be like, I think we got to fire them. And I'm like, okay, well, what have you told them? And they're like, well, I mean, I think it's obvious. It is not obvious. Nobody thinks that they're doing a terrible job. Everybody thinks that everybody is doing their best, to be honest. That may not be enough for the company, but they're trying. And so my recommendation is to really communicate the challenges, work with the individual to see if there can be, with clear communication, some reorientation and moving in the right direction. And I'll also say that this is in a formal description, it's called a PIP or a performance improvement plan. You don't have to be that formal about it. Here are the guidelines. Communicate the problems. We needed this deliverable on this date. You did not deliver it. You didn't tell us where it was. We scrambled, and then the client was upset. Okay. In future, we need you to deliver the deliverable timely, but also we're going to check in with you on week 1 to see where you're at and what you need, and week 2, so that we're not just putting all of this on you, because clearly that hasn't worked. So really trying to figure out how you can work with the individual. And you know what? It does take a lot of time. And you know what? As a founder, you don't have a lot of time. And yet, I think every human is entitled to clear communication about their work product and the deficiencies and how they might be able to improve, because a lot of people will surprise you. So that's number 1. The second item is that if you provide this clear communication, you work with the individual, it does not work out, nobody is surprised. Nobody feels like they were sandbagged. To be honest, this person may realize, oh, this is I don't even like doing this anyway, and I'm not doing a good job of it. I'm just going to look for something else. And half the time they find another job and you don't even have to actually terminate the employee. They self-select out of it because you're giving them more communication and context. But if you end up having to terminate someone, try to do it with empathy, explain the issue, explain how you're a small startup, you need X, Y, and Z, and they're not able to deliver that. See what you can do. Is there another role that they may be more suited for, that you can use your connections to help them get in that position? Can you still write a good review about other aspects of their work? Try to see whatever you can do. And then ultimately, if you are ending up terminating someone, I think it's fair to offer some amount of either vesting acceleration or cash in exchange for them signing a severance and release agreement, or called a separation agreement, where they promise they won't sue the company in exchange for something that you give them, and has a bunch of legalese in there. I think it's just nice to offer anyway, because I mean, most, like, if you're in the EU, you like can't fire people with 1 day notice, and you can do that in the US, but I don't think it's right. Like, I think it's fair for people to have a little bit of advance notice and time to be able to put something else in place. And then the company gets the benefit of capping any liability from this source. Okay. Then thinking about the transitions, this is okay, guys. This is the most unpopular hot take. Are you guys ready? The skill set for building a company from 0 to 100 is actually the opposite of the skill set for building from 100 to 1,000. So what I ask founders to do, and I think women are actually naturally better at this than men, I'm sorry, is to really think through what the needs of the company are and what your skill set is. And to be honest, a lot of founders actually are great at 0 to 100 and not at 100 to 1,000. And they don't really want to upskill and become an expert in that area. So that means as you're building 0 to 100, think through what the transition might look like. Look for somebody who is good at 100 to 1,000 that you might want taking your baby and taking them further. This is a kind of vulnerable example, but I have 2 kids, and with my first kid, we just did it all ourselves. And like my husband stayed home for a while, and we did it until she was 1. And then we put her into preschool, like daycare. And man, she did great. And her behavior was so much better. And we were like, oh yeah, these people are professionals. They're actually really good at educating and training children. We can provide the love and support, and we have that, and the direction, and the home life. But like, there are professionals. And so even for my baby, I was like, it's actually better for her to be with somebody for a large part of the day whose job it is to train small children, because that ain't my job. And I'm not as good at it as they are, So think through that for your own company baby. And think about what's best for it, and how to make that transition. Think it through. And if you're like, no, I'm with this company, ride or die, I'm going to be with this until the end, then think about what resources are needed to upskill yourself so that you are able to be an expert at the 100 to 1,000. And then also the core hires for your company, start thinking and looking about them now. It seems so early, but I got to tell you, the cycles to hire the person you need, you're always on your back foot. You're always behind the ball. If you look for these key hires in advance, and you like set the seeds and tell your network, and like if you really need a good salesperson, or you really need a good CTO, or some key hire, think about it in advance, seed it, and then you'll be ahead of the curve. And then let's next page. Oh, I didn't think I was so blabby. We only got through like half of this slide. Okay. Fundraising. Let's go on this. The key here is that the only thing I want you guys to remember from all of this whole fundraising things is that there's a way to fundraise. That there are 2 main ways from angels and VCs. One is convertible securities, which are notes and safe, and one is priced equity round. Almost all startups are starting with notes and safes if they can. The new tax law makes qualified small business stock a tax like even more lucrative. And so people are pushing back on this. But generally, you can get investors to invest in notes and safes as the first round. And it's really quick. It's really easy. They're standard forms. The thing to keep in mind, the YC form of post-money safe means that any subsequent safe or notes rounds that you raise only dilute the founder. So these companies come to me, they've raised 3 note rounds or 3 safe rounds on their own. They're so proud. They like double the valuation each time. I'm like, great. Well, those last 2 rounds only diluted you. So now you own way less than you think you do of the company once everything is said and done, once the notes convert. So this is the thing to keep in mind. If you're going to go with the standard YC post-money safe, which a lot of people do, please try to limit it to 1 round. Otherwise, see if you can get by with a pre-money safe. Okay, second is next page. Arila, sorry. I'm not going to go through this, but I'm going to say there's other options. Mostly, I would say go with a pre-money safe if you can. It gives you more optionality later on. Okay, next slide. It's easier to raise more on better terms later than go at asking for too much. So you may think of like my first raise is going to be $2 million. Maybe see what could you do something with 500K that would get you to a milestone that would help you to make the case for more money later. Because also, if you raise $2 million now, awesome if you can do that, but the valuation may be really low. You may be giving away a lot of your company in exchange for funds you don't actually need for 2 years. So think that through. Next slide, Arula. Okay, this is important. Everybody feels like they're in the supplicant position when they're a founder looking for investment, but you got to look at the people that are going to be investing in the company as well. You got to vet them. And I'll say this, it's unpopular. High net worth people who have not invested in startups are awful. Like not universally, but disproportionately. Okay. They don't have a job sometimes. They have a lot of time on their hands. They have money to spend, but they may have a lot of questions and they may not understand how things are normally done and they cause a lot of friction. So just be careful when you're taking investment. If it's a high net worth person who's like totally aligned with your company and your mission, really understand the expectation is that like you will put money in, I'll give you updates and that's it. There can't be an expectation that they are checking in every month to like see how their money has grown. This is not this is not a Vanguard account, guys. So also, if you're taking investment from a firm, there may be a really charismatic, amazing person that you're speaking with. That's their job, is to like woo companies and get them into the firm. But that may not be the person that you end up working with long term because they may leave, there may be restructuring. So really understand the whole reputation of the firm and vet, because look, you can actually get divorced more easily than you can get a bad person off of your cap table. It's crazy, okay? And divorce is also a pain in the neck. So just imagine. So this is what you're also in the interviewer as well as the interview seat when you're looking at these investors. And I also think it changes the dynamic a little bit when you're talking with investors. If you view it in that perspective, they kind of get the vibes and they also like view it as more of a two-sided thing. Next slide, please. Okay, when you're pitching, don't forget your story and your why, and like why you in particular, and lead. And I've gotten this advice from so many VCs. In your pitch deck, one of your first slides need to be why you and why, what is unique and differentiates your company. And that doesn't have to be technical skill. That could be, I specifically had this health issue, or it can be a personal story. And then your investors, half the point that you have investors is to use them for the resources. So don't forget to do that. Next slide. Okay. This is like the most boring and also very valuable part of this presentation. If you guys have seen this before, it's the Eisenhower matrix, literally from President Eisenhower. So I would say that like 90%, so much of our time is spent on urgent, not important tasks. That's like getting your inbox to inbox zero. Sorry, guys, I hate it. It's kind of a waste of your time. You need to just put shit in different folders. You don't have to like make decisions about everything. And then we spend a lot of times too on the urgent, important tasks, which are like fire drills, which is like client is upset. We got to fix the product broke. We got to fix it. You can't avoid that. But here's the secret. The important and non-urgent tasks always get forgotten unless you prioritize them preemptively. So my one homework for everybody here is to go home and on your calendar, like right after you get off of this call, set aside at least an hour a month. And the first hour, and just put it on your calendar and just don't schedule anything during this time. The first hour can just be, what am I going to use this time for? It may be identifying investors. It may be identifying future acquirers, because those relationships take a lot of time to build. It may be identifying the right type of clients. It may be talking to clients to figure out the right type of product you're creating. You can define what that is, but if you neglect this, particularly the relationships with a future acquirer or strategic transaction partner that take years to build, and you need multiple connections because people leave, their jobs sometimes and transition. that is when I've seen an amazing product, an amazing company. Like, founder disputes can kill you right at the beginning, but what kills you at the end is not having done all this work and having this amazing thing and having nobody that knows what it is or who you are or that they should be buying it. And trying to establish that with a limited timeline, investors aren't willing to reinvest. Like, it's miserable. And then you just lose all of the value that you built. So this is important, a homework assignment. Next slide, please.
Hey, Aravinda, I want to remind us of time. We're at 11:47.
Yep.
So if
Okay. So, I did want to answer. B Corp is not illegal. Oh, look, somebody already said this. All right, Leslie, thank
I got
you.
my
Look, this
answer.
is the community at work. I love it. Okay. Let's open up for questions.
Yeah. Thank you so much, Aravinda. And ladies, I promise you, we will have a V2 version
We'll
of
have
this.
time.
We will do all this. So, Helene, if you want to unmute yourself and ask your question about the standard cliff and the accelerated investing.
And no, I feel like she kind of went over the vesting. It's just kind of
Yes, thank you.
complicated.
It is complicated, but basically the answer is it's time-based. And then there are some acceleration triggers. And like if you go with a platform like Clerky, they're just going to give you what's standard and you just go with that.
Great. And then do you do like a consultation? Can you do like a 20, 30-minute
Yes.
consultation?
Yes.
Okay, great.
Free
Thank you.
consultations for everybody in this community. There's even like a
Thank you so
Calendly that I'll share. Yeah, come talk to me. I
Okay.
wanna help.
Awesome. Great. Leslie, you have a question if you want to unmute and ask about IP.
Sure. We have a patent and it's under my name and not the company. And we also have 3 patents that are pending. And I want to protect that. And my question is, when do you transfer that IP ownership to the company? I've heard that it's when you get investors. And then the other thing is, how does that work founder wise, in order to make sure that those that are in the pending process, that kind of what happens with all of that, what your recommendation would be?
Great question, Leslie. I'm not a patent specialist, so I will put that out at first. But typically when the company is created, you receive stock in the company, and often that is in exchange for the IP that you've created up until that point. After that point, you sign something that assigns future IP to the company. So usually in that first instance, when you're getting stock from the company, that's where I see, if you're working with a lawyer, they're going to have those patents transferred over. They're going to have everything appropriately done. This is important, though, especially if you have a co-founder and you're contributing this pre-existing IP and patents, that needs to be factored into equity ownership. So please don't go 50-50 when you're bringing all the patents and all of the IP with a co-founder. That doesn't make any sense. And then if you haven't done it, like doing it sooner is better. Without the structure of exchanging shares for the IP, because the argument there is like the only value in this company is whatever I'm bringing to it. So whatever shares I'm getting, if the value of the shares is higher, well, then the value of what I'm bringing in is higher. And that's why it's very elegant to do that right at the formation. And that's why the structure, like Clerky, for example, will have Stripe Atlas is fine too. Generally, don't have to fix much with that either. If you haven't done it yet, sooner is better, because it's possible that there could be a tax implication for the transfer of IP to the company. Generally not if you're the only founder, because that's viewed as a tax-free. There are ways to make it tax-free, but sooner the better. And then as long as you make sure you feel comfortable with the equity structure and vesting and everything, and make sure, you're not bringing something into the company that somebody could, take the value of as they leave.
We have a question from
IP.
Ashley.
Yeah.
The question is, what's the estimated legal cost to get set up for accepting funding? And for example, formation, getting through convertible notes round.
Yeah. So formation, again, if you haven't formed, use one of the platforms. You can just do it yourself. Like, you can ask us questions if you have nuances around like who should get what. That's the cheapest way. I don't even do clean incorporations anymore. All these firms are offering these flat fee packages. It's always more expensive, because if you make a change, you can just make that on the platform. And I've literally not ever gone through a formation where somebody hasn't made some sort of a change. So that I think Clerky's like $800 for like a lifetime membership to it. And then you can use it for like advisory and NDAs and all this other stuff afterwards. And we've actually trained our team to use their equity documentation to further reduce costs for our clients going forward. If you have questions, that education process is where it's helpful to have a lawyer, but it costs. So that's the part where I can't always estimate what it's going to look like. If you literally formed on Clerky, you came to us, we do a quick audit. We'd probably flag some securities filings that need to be made based on where each person who received stock is based. So I can't predict what that is because it varies depending, the cost varies depending on where they're based. But like, let's say like $2,000 or something for an audit, and we can identify flags excluding filing fees. And then the actual financing round, I like safes because they reduce the transaction costs because we're looking at a form. If we're doing notes, I like them because they're pre-money. You can make them pre-money more easily, which gives you, again, more flexibility and means that future it means that its dilution is shared equally between the note holders and the founders for future raises. But all of that, like a note, is actually generally a little more expensive because there's not a clear form. And there usually is more negotiation. Plus, people have side letters. It's hard to quote what that's going to look like. So you kind of have to think. I tell people like $5,000 for like a standard safe round. And it can be more and it can be less. And we will let you know what the triggers are that are going to make it more or less, depending on your situation and what works in that situation. If you come to me and like the stuff is not been on Clerky or Stripe and we have to fix it. And that I cannot predict how much that costs. And even before we fix it, we have to figure out what's broken. And that can cost money. And that's so frustrating. And I hear it. And that's why I'm out here like yelling at people to use a normal platform and not one that is not suited for startups, because it hurts me. It hurts me to charge clients to like fix the stuff that if only they had gotten good advice could have been done properly in the first place. Okay.
Awesome. Thank you, everyone. And thank you, Aravinda, for, sharing all the nuggets that you have. I want to remind you, ladies, please come to the office hour tomorrow. We will be able to answer more questions and deep dive into, more sessions. So, looking forward to seeing you all tomorrow. In order to, help you engage more with WCS, Arila, if you want to go to, so I would like to say that this event series, the Founder Series, we have few more in this series. We have marketing digital presence, which is also going to be coming next week. We will have a building confidence in pitches and leadership presence. And then finally, if you guys are in Bay Area or you're close by to come to a happy hour, we have on October 24th, we had to move it, and it will be in person at Trellis co-working space. So I look forward to seeing you all there. Next slide. I would encourage you all, as you can see, we're working really hard to bring this support to you. Please come and become a member of Women in Cleantech. We have an entrepreneurship Slack committee and Slack forum where you can communicate with each other. So please come and join us and be part of that and join hands to, be support to each other. And here's where you can find us to become a member. Next slide. You can also become a corporate member. There is a segment just for startups to get spotlight and vision for your company. The amount is lower, and you can check out for startup corporate membership out there. In terms of, next slide. Yeah, and support us through wearing and owning merchandise from Women in Cleantech. We have some amazing t-shirts which say the future is female. Next slide. And today, we cannot do this without the great effort of RAR Studio. If you guys attended Alina's conversation, the first one, she and I have collaborated to put this together, and we'll work to bring more such to you. I want to thank our marketing lead, Marie-Kay, who, puts together all of the great, social media as such. Today, our Zoom producer is Arila, our longtime volunteer and an entrepreneur herself. I want to thank her, and please come and join us if you think you can add to the volunteerism here. And with that, I would like to end our session today. Arila, if we can move
3
through
minutes.
the slides.
Does anybody have a last question? I love answering questions. So if somebody has a question, just put yourself off mute and ask it.
I have a question about what do you think about work for hire agreements? And if someone's actually doing work and someone's building, helping me design and build a mobile app.
When you say work for hire, do you mean like they're not getting paid, but if they do well, you will hire them as an employee?
No, I'm saying that if I pay them for their work, but then I own it all. Like if
that is a consulting agreement. That's what's in a standard consulting agreement. If you get them to sign a consulting agreement, you're fine. A lot of these platforms that allow creatives like Upwork or Fiverr, like a lot of them already have language in their terms of service that say once you pay in full, you get the IP, but you should double check that. But if you get them to sign a consulting agreement, that is a work for hire agreement, actually.
Okay.
Yeah. Sure.
Any more questions?
2 more minutes. Free legal, guys. Come on.
I actually have another question. So it sounds like, what you're doing is helping people form their corporation and protect and work with investors and all of that. How does someone go about finding, an attorney that actually will help me with my product? And if I have
commercial agreements, you mean, or
like liability agreements and waivers and things like
we do
that.
all of that too. Like we're general counsel for all these, but I focus on these specific categories because there are actually other attorneys that can do commercial work, but there aren't a ton of small firms, and there definitely is nobody who's mission driven like us to work with our demographic that knows about startup and the nuances of VC, because that's like a rarefied kind of category. But we definitely do that for our clients. We not only handle everything, but then when it gets to an area where you need a specialist like immigration or patent or anything like that, we have an amazing network of people that have been vetted, that have worked with our clients, that we only give, the best to our clients. So you think of us as like until you get your in-house counsel, we're your fractional in-house counsel.
Okay.
Awesome.
I have a question about cap tables. So investors asking about cap tables, if you know absolutely nothing about cap tables, other than the fact that
all a cap table is who owns what, and like when they got it, and like what the vesting is. So if it's just you and you haven't issued shares to anyone, and maybe you can look at your agreement that gave you shares. Maybe that has the vesting, maybe it doesn't. If you haven't done that, you need to do that sooner the better, because as I mentioned, there is this QSBS section 1202 of the Internal Revenue Code benefit, which I will reserve all my comments about this tax bill, this Trump tax bill, but it actually increases the benefits you receive as a startup founder under the tax rules for your stock if you hold it for 3 to 5 years and all these. So you don't get any of those benefits if you don't hold it. There are these people in stealth that have been in stealth for 2 years and they haven't issued themselves any shares. You're just losing the potential for a really good tax benefit if this works out. So keep that in mind.
One question.
Awesome, guys. Thank you so much.
If I've given...
Leslie,
Leslie, come to the office hour tomorrow. We'll have a whole convo, okay?
Okay, thank you.
Yeah, and thank you all for attending this, and we're really excited to partner with you guys to bring more of these topics to you. So have a wonderful day ahead.
Thanks,
see
everyone.
you guys tomorrow.
Please connect with me on LinkedIn. I'll share the Calendly. You guys can book time.